Thanks for joining us at dinner time. We really appreciate it, you spending time with us for this. I'm Nicole Golden. If you don't know me, I'm the executive director of Texas Gun Sense. We are a state-based, statewide gun violence prevention organization. We've been around a little over a decade. And we do advocacy work as well as education and community-based projects. This series is a very key part of the education work that we're launching here in 2024. We've got a web series we're doing every other month, Education to End Gun Violence. And this is the first one of the year, which is a topic we've been really wanting to dig into for a while, and we think that it's of great interest to others. We're calling it Beyond the Bench, on the intersection with what's happening at the courts and gun violence and gun violence prevention. And we also want to kind of give it a Texas twist to talk about, what that means for those of us who live here in Texas, what we can do, what we need to know, what we need to share with other people, et cetera. So thanks again for joining us. Really appreciate it. We have great speakers. We also have a couple staff members from Texas Gun Sense here helping me out. So thank you to Laura and Jesse. I am going to introduce our speakers, and then they're going to do some presenting, and you'll have a chance to ask some questions at the end using the chat feature, and we'll call out your questions, and depending on who's the best person to answer it, you'll get your question answered by one of the speakers. So anyway, let me start by talking about who our speakers are tonight. We've got first Shira Feldman. She's the director of Constitutional Litigation at Brady, where she leads Second Amendment litigation and amicus work and represents victims of gun violence against the gun industry. Super important work, and Brady are great partners of ours, so we really appreciate you being here, Shira. We also have Shelli, who's an attorney and violence prevention advocate at Texas Legal Service Center. She has a long history of advocating for domestic violence victims, sexual assault victims, and is a very great partner in town, and we love having her. And then lastly, we're going to hear from Jennifer Mandelblatt, the Deputy Campaign Director at United for Democracy, a coalition of over 130 organizations calling on Congress to rein in the extreme Supreme Court. So we're going to hear, lots of really interesting perspectives from these folks. And I'm gonna go ahead and start giving them the chance to present to you. So I'm going to hand it over to Jennifer first. She's going to provide kind of a general overview of Supreme Court reform and the kinds of things that they're pushing back against. And then we'll hear from our other speakers after that. So Jennifer, I'm going to hand it over to you.
Awesome. Thank you so much, Nicole, and thank you, Texas Gun Sense, for having me. Hi, everybody. As Nicole said, my name is Jen Mandelblatt. I am the Deputy Campaign Director of United for Democracy, which is a new campaign we launched in June, calling on Congress to take back its power and rein in the Supreme Court. And I'm going to talk about why. There's a lot of problems with the Supreme Court. We don't have a ton of time. So I'm going to first give a little bit of background on the capture of the court, the problems underway, what this means for gun violence prevention, and how do we move forward. So please feel free to ask all the questions at the end, but let's dive on in. So first, if your school had, however many years ago, a civics class, you might have learned about the Supreme Court as this nonpartisan sort of beacon of balance of protecting our rights, of a body of justices who were first and foremost loyal to the Constitution above all else. And while it's a beautiful story, and for nerds like me who actually carried around a pocket Constitution in high school, because that was very cool, it's a real bummer to find out that that's a sham. So it's a beautiful story, and it's not true. Because over the last 4+ decades, extreme right-wing activists and billionaires and special interest groups have worked to capture the Supreme Court and install justices and judges up and down the judiciary who will do their bidding away from the will of the people, insulated from public opinion. And that's really important because the will of the people is in favor of gun violence prevention, as you all know very well. But again, they tell this very good story. And there are a lot of flaws in this story, but the two I'm going to talk about right now is first, part of their story is that they're, again, pretending this is all about adherence to the Constitution. They and they alone know what the Founding Fathers intended, and therefore, when they hand down these really dangerous decisions, we are receiving them as if this is the word of the Founding Fathers given to us in the year 2024, when in reality, it is their interpretation. And then the second problem I'm going to talk about is that as part of this story, they like to say that checks and balances means that they get to do what they want and Congress has no role in reining them in. And once again, that is untrue and that is false. And we will talk about that. So first, let's talk about their interpretation and why this is not, again, the word of the Founding Fathers. First, the Second Amendment was not interpreted as protecting an individual's right to own a gun until about 1970, after the NRA started pouring millions of dollars into crafting a legal theory that was industry-backed and supported this claim. And in fact, in 1991, then retired Chief Justice Warren Burger, who was appointed by President Nixon, said that the gun lobby's interpretation of the Second Amendment is one of the greatest pieces of fraud, I repeat the word fraud, on the American people by special interest groups that I have ever seen in my lifetime. And so what started as this fringe theory of the NRA pouring money into the judiciary soon came center stage and started to dictate much of how we've moved forward since. Because in 2008, Justice Scalia handed down the Heller decision, which again took this idea of an individual's rights to bear arms as the interpretation of the Second Amendment and made it the rule of law. So what does this mean in practice now? Well, 2 years ago now, year and a half ago, the Supreme Court, using this guide of the sham interpretation of the Second Amendment, handed down the Bruen decision. And in that decision, they essentially said that any law, any gun violence prevention measure on the books has to have a similar law that was on the books in the 18th century to be deemed constitutional. And now this Bruen test, which was again handed down about a year and a half ago, 2 years ago, prompted an unprecedented number of lawsuits filed. According to Gifford's count, the challenges to local, state, and federal gun laws have amassed about 450 decisions applying this test that again says if there's not a peer law or a similar law from the 1800s, gun violence prevention measure is no longer constitutional. And in the last 2.5 months alone, using the Bruen test as a guide, California, Maryland, Oregon, and Pennsylvania have struck down laws designed to make our communities safer. Whether they're laws in California that were new, prohibiting firearms in a number of public places, or in Maryland, a law that was 10 years old, widely accepted, and had handgun licensing requirements. So whether it was new or 10 years old, this new test opened the door for lower courts and for people who are also in the pockets of special interest to raise these cases. When tragedy strikes, our communities deserve action. And what we're facing is a court or a judiciary that is empowered to not listen to what the public momentum it needs and wants and it is calling for, and instead, again, can do the bidding of their special interest groups. So that's part one of the story that I'm going to talk about. Part two, again, is the sham that this is a sunk cause, that there's nothing we can do about it. They really don't want us to do anything about it because the special interest groups are sitting pretty with these decisions. They're making more money as more guns get back into the hands of communities. But the reality is checks and balances works both ways. So if the Supreme Court is going to take legislative power away from the people, away from those lawmakers we elected to pass gun laws, that means that Congress has the ability to restore checks and balances and rein in the Supreme Court. And today's court is very much by the design of Congress. And the fact that we have 9 justices was from the Judiciary Act of 1869. The fact that the first woman was allowed to argue before the court was from the Lockwood Bill of 1879. That the building is at 1 First Street Northeast in Washington, D.C., 1912. That justices must disclose gifts and travel, a 1978 law. The Supreme Court's current budget, an act of consolidated appropriations in 2022. this Supreme Court is very much a product of congressional action and of checks and balances, which means that where we go from here can also be a product of congressional action, of taking back their power. But we have a court that has both a political problem, again, extreme right-wing justices doing the bidding of those who installed them, and a structural problem. We've never known true democracy in the United States. Our structures and institutions are inherently rigged against too many communities across the country. And so that means there's no easy solution. Fortunately, there's no shortage of solutions, there's just a shortage of action. Some of the things on the table right now are ethics bills. One of the ways that we get the court out of the pocket of special interests is by cutting off their access, by putting limits on their access, by just requiring disclosure and enforcement of that access. Maybe it's term limits and making sure that people don't have lifetime appointments where they get showered in gifts and get to dictate laws for generations to come, never having to bear those consequences. Maybe it's expansion and adding more seats to the bench to better reflect the way that our country has grown since 1869. Maybe it's saying that the Supreme Court shouldn't get to be the final arbiter of our rights. All this to say is that Congress has a role in reigning in the Supreme Court, but they need to hear from us that we are expecting action, that we are no longer buying this sham story, and that we are counting on them to protect our rights and freedoms. So that is a little overview of what is wrong with the court now, and how do we start to look at how we move forward.
Thank you. Sorry, Jennifer, I just had to unmute myself. Thank you so much for that. That super important overview. It's both very concerning, but also really important that we hear it. I know we're going to get into questions from the participants later. I was curious if you can offer just before we specific examples or case studies that that are going to shed a bit more light on the relevance of Supreme Court decisions happening now and their connection to gun violence in particular.
Absolutely. Well, I know Shira is going to talk about the Rahimi case, which is coming up, which has been heard in front of the Supreme Court, and we expect a decision this year. So that is a huge case, and Shira is going to have the best insight on that. But there are, as I mentioned, this is not just about the federal law. It's about the precedent that the Supreme Court can set to open the doors for judges in lower courts and in state courts to follow suit. So the fact that California, Maryland, Oregon, and Pennsylvania judges were able to strike down these different gun violence prevention measures, again, ones that were passed 10 years ago or just a couple months ago, is because the Supreme Court opened the door to this. And so now that this test is on the books, further efforts to advance progress on gun violence prevention hangs in the balance. And then in the immediate, one other example that is a little bit wonky is there's this thing called Chevron deference, which essentially says we trust agencies to experts to do their jobs. And so right now, the agencies are finalizing a rule on bump stocks. But because the Supreme Court continues to take away power from the other agencies and take lawmaking power for themselves, means that they can stop regulations and action. So as everything continues to move forward, as progress continues to rise, the Supreme Court's new test makes it harder for progress to stand. Now, I'm not saying that all hope is lost, but I'm saying that there is a real threat.
Mm-hmm. I'll also ask you one more thing that our staff had really wanted to bring up tonight. And if you think you're the best one positioned to answer it, or if someone else, you can certainly let me know. But are there specific policy recommendations or changes you would suggest that would help create a more effective and equitable legal framework?
Absolutely. So as I mentioned, there's a couple of different pieces of legislation or frameworks for how we fix the court that are in discussion and underway right now. Again, ethics, term limits, expansion, disempowering. And we at United for Democracy have not yet endorsed a solution because, again, we understand that this is both a political problem and a structural problem. And if we only get one bite at the apple, we want to make sure that we are throwing our weight as a coalition behind a reform that really hits across the board. So where we are now is, again, there's the ethics bill, there's legislation called the SCIRT Act that Shelli Whitehouse introduced. Term limits, Representative Johnson has introduced legislation on that. Expansion, the Judiciary Act, which I believe Senator Merkley is the chief co-sponsor. Don't quote me on that. And then disempowering, which is a bit of a newer conversation. But all of these pieces of legislation are before Congress, but is our theory of the case and our understanding that Congress is not going to stick its neck out and take bold action, and the bold action we desperately need unless they feel like the people are behind them. So the most urgent thing we can do right now is start calling on Congress to say, we are behind bold action. There's no shortage of solutions. There's a shortage of action. It's on you.
Perfect. Thank you so much. Those are super helpful answers, and really appreciate your expertise. And people, hold on to your questions if you have them for Jennifer. You could certainly load them now. We will get to them when all speakers have gone, but if there's something that you really want her to answer, feel free to load them into the chat now. We had planned on having Shelli go next. I'm wondering, Shira, if you're ready, if you would jump in, because I think it would be a perfect transition after to follow Jennifer, especially because she knows that you're going to lend your expertise to talking about the Rahimi case, and then we'll funnel it down to kind of some from a Texas advocate, which is Shelli, at the end. How does that work for you guys?
It's fine with me.
Perfect. Okay, so thank you again, Jennifer, and we're handing it over to you, Shira. And I think that, we had you kind of plan a similar presentation to Jennifer. Jennifer's where you're going to talk about your expertise on the Rahimi case, and understanding various legal nuances that you think people need to know. So there you go. Thank you.
Great. Thank you so much, Nicole. And thank you for your ongoing partnership with Brady and for having me here to speak. And thank you, Jennifer, for speaking so eloquently about some of the critical issues we're facing right now. So I'm going to talk about a case that's pending before the Supreme Court right now that Jennifer mentioned, United States versus Rahimi. It is a case that comes out of Texas. But in order to talk about it, we need to take a step back and talk about the Supreme Court's landmark decision from June of 2022, which Jennifer mentioned, and that's New York State Rifle and Pistol Association versus Bruen. And in order to talk about Bruen, we should take one more step back very briefly and just talk about the Heller decision for a moment, which Jennifer also referred to. So District of Columbia versus Heller was decided by the Supreme Court in 2008. And before that, the Supreme Court had really only defined the Second Amendment as referring to a collective right related to militia service. But in Heller, the court decided for the first time that it's actually an individual right, which it said is to defend what it referred to as hearth and home. And after Heller, trial and appellate courts had to struggle to figure out how to analyze Second Amendment claims. They ultimately settled on a framework that's based on how courts analyze a lot of other constitutional rights. And then in June of 2022, the Supreme Court decided Bruen. And in Bruen, the court struck down the New York law that was being challenged, but it also rejected the test that courts had been using for the 14 years since Heller to analyze Second Amendment challenges. And it created a whole new constitutional test for the Second Amendment. And I just want to talk about what that test is for a moment, because it's helpful in understanding how we got to the Rahimi case. So under that test, the first question you ask is whether the conduct that a law restricts or bans falls within the plain text of the Second Amendment. If it does, then the government defending the law has to put forth evidence of a historical tradition of firearms regulation in the United States and show that the law being challenged is analogous to laws from earlier in US history. It's important to note that the court said that an analogous law does not need to be a historical twin. It needs to just be relevantly similar, which are the court's words. But it does need to be relevantly similar. And it's a bit of an open question right now as to what exactly the time period for the relevantly similar laws is, but we know that it's some time ago. We know that, for example, 1791, which is when the Second Amendment was ratified, and 1868, which is when the 14th Amendment incorporated the Second Amendment to the states, are critical dates. And as Jennifer said, the Bruin decision opened the floodgates to all kinds of litigation challenging gun safety laws. There have been over 450 challenges to gun laws post-Bruin. And to give some additional context for that number, I want to note that a significant percentage have been in the criminal context, where someone is challenging a prosecution or conviction based on the Second Amendment as interpreted by Bruin. So one of those criminal cases is United States versus Rahimi, and it is set to be the first decision from the Supreme Court to interpret gun laws under the Second Amendment after the Bruin decision and applying the Bruin test. I want to talk briefly about the facts of the case, and then I'll talk about the potential implications of whatever the Supreme Court decides. So first, just to understand what the law is that's being challenged in the Rahimi case. That law is 18 USC section 922G8. It's a federal law that bars someone from possessing a firearm if they are the subject of a qualifying domestic violence restraining order. I want to make clear that this is a law that saves lives. I'm sure Shelli will talk about this, but the law has a couple of important roles in addressing the very terrifying reality of what happens in a domestic violence situation when a gun is involved. So one use of the law is that people can be prosecuted for violating it. And we know that in, for example, states with similar laws, there's a 13% reduction in domestic firearm homicide statewide. And in cities with similar laws, that number is even greater, it's 25%. But another role of the law that is at least as critical is that it's a critical part of the federal background check system. So when someone goes to buy a firearm and a background check is conducted, this law means that a person who is the subject of a domestic violence restraining order that qualifies under the law is blocked from making that purchase. And that is extremely important. Since the current background check system was put in place in 1998 through the end of this past year, that law has prevented 78,604 firearms purchases by individuals subject to domestic violence restraining orders. So the Rahimi case that is challenging this law. Zaki Rahimi was subject to a domestic violence restraining order because in 2019, he assaulted his girlfriend in a parking lot and he fired a gun at a witness who saw what had happened. He then repeatedly defied the order and was subsequently arrested for violating it. In November 2020, he was charged with aggravated assault with a deadly weapon after threatening another woman with a gun. And then he was involved in 5 shootings around Arlington. And when officers searched his home after the shootings, they found firearms, ammunition, magazines, and a copy of the protective order that barred him from possessing firearms. He was then prosecuted and convicted under this law. And when he first challenged it, the Fifth Circuit, which is the Federal Court of Appeals for Texas, said that the law was constitutional. But after the Bruin decision, it changed its mind and it said that the law is unconstitutional. So what are the implications of this case and a decision, and what are we looking forward to? The federal government asked the Supreme Court to hear this case after the Fifth Circuit found the law unconstitutional, and the Supreme Court agreed to do so. And as I mentioned earlier, Rahimi will be the first merits decision from the Supreme Court on a Second Amendment case after Bruin, which means that the decision has a potentially significant impact, not just on this law and possibly similar state laws, but also for litigation concerning gun laws more generally, as the lower courts continue trying to figure out how to interpret and apply Bruin. There are really 3 scenarios that could occur with the Supreme Court's decision. The Supreme Court could reverse the Fifth Circuit and find that this law is constitutional, but it could do so in a very narrow way. Or it could reverse the Fifth Circuit and find the law constitutional, but write more broadly about how you apply the Bruin test. Or it could affirm the Fifth Circuit's decision and find the law unconstitutional, which I think we all agree would be a disastrous outcome. What I want to talk about is the potential for that second option, where the Supreme Court reverses the Fifth Circuit, finds the law constitutional, and writes a broad decision that would shed some light on how to interpret Bruin going forward. And I just want to give some examples of what that decision might talk about. At the oral argument in Rahimi, which was on November 7th, Justice Kagan asked the Solicitor General about what issues the court might clarify about Bruen when it decides Rahimi. And the Solicitor General provided three. She said one is that the Supreme Court could make clear that when lower courts look at the history that Bruen commands them to examine under its tests, they not only look at the history of regulations, there are other histories that are relevant. That might include state constitutional precursors and treatises and commentary and state judicial decisions. There are a lot of different written works we can look at for this information. Second, the court could make clear that in looking for historical analogs to modern laws, you don't need to have this historical twin. And instead, courts should be looking to historical laws to distill principles that define the scope of the Second Amendment. And third, and I think this is really important, the court could clarify that historical silences, the absence of a regulation on a particular topic or in a particular area, are not proof, dispositive proof that a modern law is unconstitutional. Many silences in the historical record in no way suggest that a particular law was not enacted because someone thought that enacting it historically would be unconstitutional. There are lots of other reasons that laws don't get passed. Sometimes they don't get passed because a problem didn't exist before. So this clarity from the court would be really welcome and would give us a lot of more information about how to defend gun laws going forward. But having said all of that, I just want to emphasize again the stakes in this particular case. As the Solicitor General reminded the court at the beginning and closing of her oral argument, she quoted the court's own words. And what she said is, all too often, the only difference between a battered woman and a dead woman is the presence of a gun. And with that, I'll turn it back to Nicole and then to Shelli to talk about why that's so scary.
I do have chills from what you just said. I'm sure everybody else does. It is extremely chilling, but important that we hear those words said again. So thank you for echoing those. And we're going to hear from Shelli in a minute. So I don't know if you want to answer this, Shira, or if we should wait. But a burning question for me and for us is just what's the potential impact on the Rahimi case on communities? And those of us who are advocates for this cause, those of us who are trying to protect women and families, and those women, and families themselves who are at risk.
So I think there's probably a lot Shelli can say about that, but I do want to just flag one thing, which is the potential consequences for state laws if we were to get a bad decision here, right? And not just necessarily state domestic violence laws specifically, but also extreme risk protection order laws, depending on what kind of bad decision you got. I do also want to say, though, that we are optimistic about the outcome here for whatever that's worth.
It's worth a lot. Thank you. Thank you so much. That was incredibly insightful. Shelli, we're gonna go to you next, and just to remind everybody, Shelli is a Texas-based advocate. She works with domestic violence victims and in the legal system. She's going to talk a bit about how how these cases present and what they mean for our community and especially those who are vulnerable. So, Shelli, you have the floor.
All right. Thank you, Nicole. And I'm so excited to be here with Jennifer and Shira both. I really respect their work and I'm so appreciative of this opportunity to talk about this. I think Nicole knows that I will talk about this issue any chance I get in any forum because I think it is so important. And as she said, I'm a legal advocate. I'm a legal aid attorney. I've been a legal aid attorney in Texas since 2010. And that's how I got interested in this issue. I wasn't a gun violence prevention advocate beforehand. I'm actually the daughter of a gun owner. I'm a gun owner myself. So I look at it from I think a unique perspective. But as an advocate who has worked with domestic violence victims for so long, I know that this issue is one that sort of trumps everything else. All of the protections that we have available under the law to protect victims of domestic violence and sexual assault and stalking are really limited by the way that we treat this issue of firearms. And when we're looking at these types of harms, sexual assault, stalking, and domestic violence, I sort of refer to those as gender-based violence more broadly, because it is something that is rooted in the power and control. And we know that one of the reasons why the issue of firearms makes these types of crimes so deadly is that dynamic of power and control. It really exacerbates that dynamic. And we know that in an average month, there are 70 American women who are shot and killed by their intimate partner. And so I think there's a whole lot of data out there that Texas Gun Sense and every town, a lot of our partners at Brady are great at putting all of that data out there. So I don't really want to spend too much time on that, but I want to talk about the dynamic of how we treat these types of crimes as opposed to how we treat other types of crimes, especially here in Texas. I think that it would be really hard for anyone to imagine if you called law enforcement and reported a robbery, that they would ever tell you that, even though the person who robbed you was convicted, that they're going to just trust that he would turn over his firearms and that they're going to let him keep them. Otherwise, they're not going to actually go and try to take that firearm. But that's what happens every day in the context of gender-based violence. When someone under Texas law, we have a Texas law that mirrors the law that's at issue in the Rahimi case, that says that you become a prohibited possessor under certain conditions. When there is a misdemeanor conviction for domestic violence, when you become subject to a protective order for either stalking, family violence, or sexual assault, or when you are convicted of a felony. And what happens every time one of those triggers, so to speak, forgive the bad wordplay there, but whenever one of those triggering events happens and someone becomes a prohibited possessor, the law says that the judge is required to admonish them both in writing and orally in court, if they're in court, that they are now a prohibited possessor. But then not much happens after that, because the law was not written to sort of give anyone the authority to then go and enforce that. And so what happens is that a person receives a protective order, or they receive an order that says you're convicted and now it's a crime for you to possess this firearm. But we rely on this, what we call the Texas honor system, to hope and pray that they're going to turn over those firearms, or that they're going to dispossess themselves of those firearms. So there are, in other states, there are laws that are more specific that say that once you become a prohibited possessor, here's what has to happen, or here's who is responsible for ensuring that you are no longer in possession of firearms and ammunition. But in Texas, we don't have that. We do have certain areas that have tried to implement what we call firearms surrender protocols, where they're going to try to ensure that those firearms laws are being enforced. But they have been met with very limited success, primarily because the law here is so vague and does not give anyone the specific authority to enforce those laws, or anyone the specific responsibility to ensure that they're being enforced and abided by the prohibited possessors. For example, in King County, Washington, they've had a lot of success in enforcing their firearms laws there, because they got $1 million grant that was a city and county joint effort to use plainclothes officers who would go out at the time they were serving a respondent with a protective order and talk to them and say, you're now, prohibited. We would like you to turn over your firearms. Will you do that for us now? And in some cases they got that. And when they didn't, there was a system put in place to ensure that someone was then following up with the court and letting the court know that this person is a prohibited possessor and they haven't turned over their firearms. Now we need a court order to go and serve a warrant to try to enforce that law. And so there are all of these mechanisms in place to make sure that that law is being enforced every time, equally and fairly. And that's why they've had a lot more success up there in enforcing their law in King County than we have had here in Texas. Dallas, for example, is one city that tried to implement a firearms surrender protocol, but after being in place for a couple of years, they only had a handful of firearms that were turned over because there was not this enforcement mechanism, and there wasn't money dedicated to it. There wasn't dedicated staff who were given the task of ensuring that those laws were enforced every time. And so I think that one of the things that's most important to know about Texas is that our laws are not, they're not written to ensure that they're being enforced in this regard specifically. And I think that that's one of the, when I think about what could happen after Rahimi, I think I'm more afraid of the rhetoric behind the decision than I am of the actual ruling, because regardless of what happens with that decision, even sort of the facts of Rahimi can illustrate this problem, right? Rahimi was not the law, although he was arrested and charged with being in violation of that protective order that was issued against him. That didn't happen until after he went out and caused all this other harm in the community. It's sort of this idea that as long as you're doing it at home, as long as it's only one person, the victim of this violence, that you have, already been shown by a court of law that you are causing harm to this person. As long as you're sticking to that, we're not really going to do a whole lot to enforce this law. But when you go out and you're firing a gun in public and you're shooting at officers, then we will act to try to enforce this law. And that's often how it comes about, because the federal law that prohibited him from being in possession, as well as the Texas law that prohibited from being in possession of that weapon, are very, very rarely enforced. When they are enforced, they're enforced in this way: when something else has happened, or they're enforced when a traffic stop turns up a gun that is in a vehicle, and they realize, oh, this person who we stopped and wanted to charge him for something else also happens to be a prohibited possessor. And so it can be used to increase the penalties, and in that way it is one of the tools that sort of reinforces the dynamics that lead to disproportionate enforcement in communities of color. So that's one of the concerns, is that the law is not enforced equally on everyone when it is enforced, and more broadly in that it is hardly ever enforced to start with. And I think that I see this as an equal protection issue. I think that so often when we're talking about these cases, even in listening to the oral argument, most of the arguments, although there were references to the problem that we're trying to prevent here, which is domestic violence homicide, or domestic gun violence, most often the arguments are centered on the protection of that Second Amendment right to defend the hearth and home. And there's so little focus on the other side of the gun, what's happening in terms of the life and loss of life and liberty that domestic violence victims face every day. I can tell you that from my own experience, the homicides that we're trying to prevent are really just the tip of the iceberg. What I saw more often are the victims who live in a home where the gun stays on the nightstand, or where the gun is on the kitchen table during an argument to remind her where her place is and that she better not step out of line too much. And I have seen over and over again that judges are reluctant to enforce those laws, even in that context. And so there's a huge risk. It's not just the risk of homicide that we're trying to prevent, but it's also that power and control dynamic that allows someone with a gun to often be the kind of person who uses intimate partner violence, but does not have some of the signs and symptoms. It's much easier to control your victim by having a gun on the nightstand. You don't have to use the actual physical force as often. So that victim is maybe less likely to have a black eye or a bruise or the things that people typically look for when they're looking for the signs and symptoms of domestic violence, because her abuser doesn't need that. He's got that gun there to constantly remind her that he is in control of that situation. And that's one of the things that makes it so deadly and so scary. And we're just watching really closely to see what happens, with this decision.
Thank you. Thank you so much, Shelli. Again, I have chills from things that you guys are saying. I've heard you talk about that gun on the nightstand scenario too, but I think it's really important to kind of put ourselves in, imagine and all the many ways that firearms can be used to harm people psychologically, emotionally, and physically. In a minute, we're going to go to questions from participants, but I wanted to ask you, we're an advocacy organization. People here tonight are all advocates in some way or another, care about this issue. What actions should people be taking? What kind of policies should they be advocating for that you think are, we need a lot of policies in place here, right? What do you think is urgent and immediate that people should be advocating for?
I think in every single community in Texas, we should be asking our elected officials, our the chief of our law enforcement agencies, how do you enforce these gun laws? How, where, when, what are the procedures? Because that's the big thing, is that somebody who receives this order that says they're now a prohibited possessor, they walk out of the courtroom without even knowing how to comply most of the time. Because in all 254 of Texas's counties, there isn't a single one that has a comprehensive plan in place to enforce these laws about prohibited possession. So there isn't a single place in Texas where, if I am a prohibited possessor, here's where I need to turn in my guns. Here's how I give them to them. Here's how I show compliance with that law. Here's who's going to make sure that I'm complying with that law. There's not a single county in Texas where a victim knows, how do I make sure he actually turned over that gun? How do I know that I can sleep at night? How do I know that I can, walk to the grocery store without him, walking up and shooting me on the sidewalk? So that is something that I think everybody can do, is ask, how are you enforcing this law? I think that's especially important right now when we're facing so many different challenges, like, our attorney general has filed suit against certain district attorneys who they say are not enforcing marijuana laws. And, without debating the merits of that, I think it's equally important to ask, what are you doing to ensure that we're enforcing these laws that were designed to protect domestic violence victims from the extreme risk of homicide? So that's something that I think everybody can do, is ask about that.
I think that's super helpful. And I think that is something that everybody can do, and whether you're working on this in a professional capacity or not. I put, just as you were talking, I put a resource into the chat from our friends at the Texas Council on Family Violence. They're honoring Texas Victims Report that you and I know very well. Saw somebody from TCFB here earlier, I think. They're important partners, and this report is really, they put it out every year. And it'll dig into domestic violence in Texas in general, but they really do narrow down on the intersection with firearms, how many victims are shot and killed every year. Compelling pieces of information, like the fact that firearms account for the means of death in over 70% of intimate partner homicides in Texas. So just adding that as a resource. But thank you, Shelli, for all that you do for our vulnerable families. We've got a few questions in the chat. So Jesse, were you going to help field these?
I think I was going to.
Oh, Laura.
Yeah. All right. So I'm going to start with the question about, does Rahimi case influence possession of firearms by convicted felon cases?
So I can address that. So not directly, depending on because the law at issue in Rahimi isn't specifically about convicted felons, but what the court decides and how it decides it could inform other challenges to those laws. And there are a whole bunch of challenges pending right now, including one that is where the Solicitor General has sought cert from the Supreme Court. That case is Range, and it's coming out of the Third Circuit. It's a Pennsylvania case. And the Solicitor General asked the court to take cert on it, but wait to hear it until after Rahimi is decided. Right now, it seems likely that that's what the court is going to do, but we can't know for sure until actually Rahimi is decided. But there are a lot of those challenges going on, and I think because they implicate federal statutes, it is pretty likely that we'll see something about that in front of the Supreme Court sometime relatively soon.
Sherry.
The next question is, if the Supreme Court agrees with the lower court in the Rahimi case, would we expect potential challenges by similar cases to the new decisions in the future?
So I want to make sure I understand the question. I think if the Supreme Court agrees with the Fifth Circuit here that the law is unconstitutional, then that law is unenforceable, right? So the question is, what are the implications for other similar laws? And probably we already are getting a lot of challenges to them, right? Like with the convicted felons, but also there's also a case where the Supreme Court has been asked to hear it about habitual drug users. And there are some other similar challenges. So those are already happening. And if we were to lose in Rahimi, we would certainly see an even bigger groundswell. But the reality is these laws are already being challenged quite a lot in the lower courts. Bruin really just opened the door to that.
Someone asked, just confirming that we won't ever know a specific day that the Rahimi decision will come out, just sometime in June and July. Is that correct?
Yep. June is probably the most likely, but that's right. The only thing we will know is the Supreme Court announces when it's going to announce decisions. So if you're anything like me and you're watching this obsessively and you know that there is a decision day coming, you can helpfully log on to SCOTUS Blog's live chat and get in real time the information as to which decisions are coming out as they come out, as they're being announced, and what they say. But other than knowing which days are decision days, and as you get closer to the end of the term, you know which cases have not yet been decided, you otherwise just have no idea. That's right.
I will just quickly add that February 8th has been added as a decision day for cases that have already been heard this term. Again, we don't know what cases that will be. There have already been a number of cases, but that is coming up.
Laura, I would also just add to the last question about challenges to other laws. I will say that, you know, Texas advocates are watching so closely because we feel, you know, that if the Rahimi if this law, the federal law falls under Rahimi, the Texas law will soon follow suit. The Texas law that applies to protective orders, and we are, you know, also concerned about the other Texas laws that exist as well, just based on the however this ruling is structured. We're watching that closely. So I think that will be something for folks to watch out for is how we can continue to advocate at the state level that, you know, these laws were enacted for a reason. That reason still makes sense, even if the federal law falls, that those should remain in place.
Thank you. Alicia asked, are there other states that have programs that collect guns from perpetrators enforcing the law?
There are, like I said, King County in Washington is one of the earliest pioneers of this kind of project. They've been at it for the longest, so they're probably one of the best examples. I'm not going to say that it's a perfect system there, but I will say that they have invested serious resources into it, and that's one of the reasons why it's effective. They also made sure to give it the enforcement mechanism some teeth, which is something that we definitely do not have here in Texas. Louisiana is also a state that in certain jurisdictions where they have seen some success, where that their systems are more driven, not necessarily by statute, but by law enforcement officers who have been committed to really ensuring that in their jurisdictions they're enforcing the law really well. There's a sheriff there in Louisiana that has done a really good job at implementing certain protocols. So there are other states to learn from for sure. And I think that that's one of the things that definitely we have to look at what has been successful elsewhere. And certainly even in the context of extreme risk protection orders, that's one of the things that I've cautioned over and over when we discuss that here in Texas, is that if you're going to do that, you at least need to learn from the failings of how these laws are enforced in the sense of domestic violence cases, in order to understand what it would take for an extreme risk protection order to actually work here in Texas.
And I'll just quickly add, Shelli, we do have some forward movement in some parts of Texas with the, including here where we live in Austin Travis County, to try to develop protocols for firearms transfers. I know the process can be kind of slow, kind of cumbersome, but my understanding is there are around 10 Texas counties that have some form of oversight, but probably not quite the model that as Kings County.
Right. Yes. Yeah, we definitely, we've been working on it here in Travis County since 2013. So it is certainly a long process, but there are places that are making progress.
Janice asked, do the various organizations represented here this evening have a plan for a major media event when the Rahimi case is decided? Seems like something should happen immediately in Arlington.
I'm gonna defer to Shira again, if who's been part of the efforts to organize some incredible work around the case in DC and on the ground in front of the court. But one thing I just want to say about this decision, and however it is handed down, whether it's February or June or July, is what's really important to remember, and I sort of put this in the chat, is regardless of the decision that's handed down, like, if the decision is not as dangerous as it could be, we should absolutely take this as a sigh of relief, and we should breathe more deeply about it. But when we all sort of think about how we respond to what this decision is, it's important to remember that because of how radical and dangerous and extreme this case is, again, because it's being funneled through folks like Judge Kaczmarek in your state, who hears 90% of cases brought to him, which means that when Ken Paxton says, we want to challenge a law, let's go to Judge Kaczmarek, it makes it a lot easier. The Supreme Court kind of has two options in this scenario. One, where they're moving the law to the right and allowing guns back in the hands of domestic abusers. That moves the law further to the extreme right. But even where they don't do that, they are staying with the status quo that is already too dangerous for our communities, for everything that we have talked about tonight. And so when we just think about how we respond, there might be incredible works or events in the process, but we want to make sure that the narrative isn't just, great, we're all saved, the problem's over, we're good to go. It's no, we are still facing a court that is making our gun violence prevention laws less able to protect our communities.
Laura, it looks like we got through the questions, right?
Yeah, I think that was, let me check and make sure. Yeah.
Perfect timing. We're about 4 minutes out. I think there was some things you wanted to share with folks.
Sure, yes. Well, thank you so much, everybody. We're really so pleased. Thank you to our speakers, and thank you so much for everyone for being here. It was incredibly interesting and so powerful. I just wanted to close by saying that Texas Gun Sense is a nonprofit organization. We're a 501c3. And our mission is to prevent gun violence and other gun tragedies in Texas through education and partnership and policy change. This is an example of our education part of that mission. And I just wanted to, again, thank everyone for being here. And if you would like to support our organization and our efforts to prevent gun violence and to educate, please visit txgunsense.org/donate. You can become a member, which really helps us a lot with our mission. So thank you again so much for being here. And I'll kind of look around here. If any more questions are coming up, maybe we can follow up offline. But thank you again so much. Thank you to our wonderful speakers. And have a good night.
Sorry, I'm just going to echo that. Thanks again, Jennifer, Shelli, and Shira, and for our staff who set this up. I see someone's actually asking about what the dates are for future events. We will get those to you right away. Then we're doing these every other month. The next one is in April. We've got a lot of interesting topics, including hearing from gun owners in Texas, hearing from survivors, talking about community violence intervention and the importance of those strategies to reduce violence in communities hardest hit. We'll be talking more about the legislative session as that gets closer, because we'll be in another session this time next year, and a lot of other ideas. I think Jessie put her email address into the chat. If anybody wants to reach out to her and just ask how more specifically how you can get involved, or make sure that you're on our list, things like that, she would be happy to to interact with you, but please do stay engaged. We want you with us at these events. We want you with us at the Capitol, and we do need your voice. And we really appreciate your engagement. Thanks again to our brilliant speakers for shedding light on these really critical issues.
Thank
Thanks
you.
for having us.
Thank you so much.
Good night.